Hey YouTube family and GN subs, how are you? Hope you're doing great. I got great news for you despite what's happening overseas in Ukraine. We're going to give a peace sign, so that we can have peace over there. And as usual, during the pandemic, I continued to give you good news. Today I'm going to do the same, give you great news. Hopefully you could take a break, from the negativity, give you something good, give you some hope, good stuff to think about, all right? And those of you who are new to the channel, hey, do me a favor. We have some great stuff. Two areas. We have our playlist that organizes content, makes it really easy to understand. Second thing we have is frequently asked questions. You can click on that. You can see the questions that I get most often, during the comment section, and I take time to answer them. But if you look at what we have, I'm telling you, organized very well. You're not going to find another channel that does that. And we provide you with good news, break down complicated subject matter, and give you real-time cases. I got some real-time cases today. Very cool stuff, guys. All right, so let's get at it. We got some great stuff on EAD, the new policy for EAD issuance of work permits. Now it's 2 years. I put a link in the description box below. Let's dig in a little bit, right? Because you got three sections. The first section is with regard to those who have withholding of removal. That's if you're in removal proceedings and you're granted something a little bit less than asylum. It also applies to asylum. It applies to refugees. It applies to VAWA, Violence Against Women Act. Those EADs now are issued for a 2-year period, right? They were previously issued for 1 year. You had to file again, blah, 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 blah. It was really difficult. Why are they doing this? The reason they're doing this is because there is a substantial backlog for issuance of work permits, right? So they're figuring, so let's issue the work permit a little longer so we don't have so many extensions going through. My prediction, folks, it's going to also apply to normal adjustment of status under 245A. I think it's going to be extended to that as well. Let's talk about the second big development here. So spouses of L1s, intercompany transferees, spouses of E1, E2, treaty trader, treaty investors, those who invest in the United States, the spouse obtains an automatic work permit. Previously, what we had to do, we had to file. It would take months before they would get the work permit. Now under the new rule, it's great. Validity of I-94 equals work permit. All right, so L1s in some instances get 3 years on the I-94, automatic work permit with I-94. So if you're going for a job for I-9 purposes, you can give them the I-94 alone. That indicates that you do have authorization to work. Same thing with E1, E2s. Generally, the I-94 in the U.S. for 2 years at a time, so you're going to have automatic extension of the work authorization under the dependent E1, E2 category. So that's a great development. No more filing for work authorizations, etc. Automatic on the I-94. Third, the H4 dependent of those who are on H1 visas. So what they've done in that category is automatic extension of the work permit with a timely filing of extension for the work permit. It automatically extends your EAD until the new EAD is issued. Another bit of good news, premium processing, right? So you pay good money to have your case adjudicated within 15 days. These are non-immigrant visas and some I-140s. It's not happening. You're not getting the receipts. What do I do? Where do I send an inquiry to? So AILA, the American Immigration Lawyers Association, just updated where you can inquire, phone numbers to call, email addresses to send your inquiry. I've put a link in the description box below that delineates, it outlines specifically that information, which is great for you. So hopefully you can use that, be successful in getting your premium process completed. Here's a real bit of good news. Public charge rules, they are going to be scaled back again. There's a new definition for public charge that Alejandro Mayorkas and USCIS has promulgated. That is, under the previous administration, it was likely to become a public charge. That was so broad, that would include anyone. Then they had that dumb 944 form that was so incredibly long, no one could complete the darn thing. All right, so they're gonna change the rule from likely to become a public charge to likely to become primarily dependent on public assistance, okay? Big difference. All right, I wanted to go over something that's kind of important, right? A lot of times applicants get confused on rules regarding I-140 retention, and if you get a new job, what do you do, right? Labor certification, I-140, generally it's going to take years, sometimes 2-3 years, and then if you're from a country where the priority date's not current, you're going to have to wait, right? So you're waiting sometimes up to 10 years. And what happens while you're waiting, you get a new job. What do? Do you file a new labor certification with a new priority date and wait another 10 years? It'll be a non-ending circle. So retention of priority date is the key, right? So what happens is if you get a new job and they're filing a labor certification to I-140, you can keep the earlier priority date provided that it was approved. That's the rule. Very simple. What's the difference between retention of priority date and portability? So portability happens where the priority date has become current. You have filed the adjustment. It's been pending for at least 6 months. You get the new job. Then with a letter from the new company, you can continue to get the green card. It's called portability, right? We had some issues in the office regarding some real cases. And so I went and I looked it up and I go, wow, let me share this on my YouTube channel with my YouTube family. Let's get to some real cases. First case, I-751 joint petition, together, good evidence submitted, interview waived. They're still waiving the interview, folks. That's good news. The second case, you've never seen it before. Okay, it's called family unity. So this is under the old amnesty rules. If your spouse got his green card through the amnesty, that is, if he entered the United States before April 1st, 1982 and was unlawful, Reagan gave green cards. A lot of people are in this status. They have green cards. If you have a spouse or child under 21 in 1988, May of 1988, guess what? They qualify for family unity. What does that mean? That means they can't be removed. That means they get a work permit and they remain legal in the U.S. That's a benefit. Look at this case. This is a family unity. Look at the FUG code. All right, it's for family unity. A lot of people don't know that, but hey, I'm on top of stuff because I've been around a while. All right, YouTube family. Thanks so much for watching GrayLaw TV. Click below, like and subscribe. Go to the frequently asked questions. Go to the playlist. Get some immigration knowledge for free. Get how to do this for free. All right, we'll see you next time.